Last case on the docket is Etheredge and VANA versus Walt Disney World.
Are you ready, Your Honor?
Just a minute. All right, you may proceed.
Good morning. My name is Jack Nichols, and I represent the plaintiffs in this case who below and the appellate here. This is an appeal that was taken because the trial judge denied my client the rights under the Article 8, Section 22 of the Florida Constitution and the Eighth Amendment to the right to a jury trial when it granted the defendants a motion for a directed verdict at the close of the defendant's case. In this case, a different judge had denied a motion for summary judgment prior to the trial, and even during the trial judge had denied a directed verdict for the defendants at the close of the plaintiff's case. Because there were genuine issues of material fact on the issues that were before the jury, this was reversible error. The evidence at the trial, the plaintiff's contentions was that the method of operation of Walt Disney World was such that they had a duty and a responsibility to provide a safe environment for their guests, including this 15-year-old client of mine who was there on July the 4th, in the evening of July the 4th of 1998. And the property was designed so that people who arrived in vehicular traffic had to park in a parking lot across the street from downtown Disney. In order to get to downtown Disney, they had to exit their vehicle and go through various markings that were marked for people that were incapacitated to get to the
I think you make the argument that had they just placed the hedge over about 5 feet to dissuade people from crossing the median at that point, it would have prevented the problem. Well, suppose there wasn't a hedge at all. Would you still take the position that it's negligence to have a storm drain like that on the street?
No, sir, Your Honor. The expert witness that I had indicated that when you plan something like this, you have to plan for the pedestrians to do exactly what my client did. And in this particular case, what they did is they designed a storm drain along the curbing of the sidewalk, just like one would expect. But this was not a typical crossing. But because of the way the path was designed and because of the location of these hedges, my client and the people that were with her testified.
They had two hedges, one on either side to channel the pedestrians.
Yes, sir.
In between the hedges.
Yes, sir.
That's your argument. One of your arguments.
The key point of my argument, Your Honor, is that they developed a method of operation where they put an attendant out in the street, and that attendant was directing people to cross the street. And that attendant had a perfect view of that storm drain as he saw my client approaching. But my client did not have that same view.
What was the evidence about the attendant?
The evidence was that two other witnesses, including my client, saw the attendant out in the street dressed in some Disney attire and had a light wand. And he was directing people across the street at that very location where there was a storm drain. And as you approach it from the parking lot, it's not obvious that there's a storm drain.
So the evidence was that the attendant directed her to step off the curb at that point and cross the street at that point?
Yes, sir. The testimony was that he waved her across and she looked to see whether the cars were indeed going to stop, and as she looked for the cars to stop and she looked back at him, she stepped. And when she stepped, doing what any normal person would do, I think, under the circumstances, because the most hazardous consequence to her would be the car hitting her. And so she was engaged in an activity which they themselves created in their method of operation. And it is my position that they pled comparative negligence, and so if they wanted to argue to the jury on closing argument that my client was comparatively negligent in stepping into this thing as she did, then that would be an issue. But this is not a situation where you enter a directed verdict. The McCain versus Florida Power Corporation case indicates that this is not such, when there's foreseeability issues concerning a matter like this, that's not a situation where you would grant a directed verdict or a summary judgment.
You stipulated that they were not negligent in the design of the storm drain or the maintenance of the storm drain.
The storm drain itself, Your Honor, is well, as a matter of fact, the defendant tried to bait me into saying that the storm drain was defective. The storm drain was not defective, and my expert testified that that is a typical storm drain that is authorized under code. But under the code, there is a statement that states that this it states limited pedestrian safety. On the code itself, it says limited pedestrian safety. And so what that means is when you use a storm drain, and it was used in the correct manner because it was in the middle of the street. It wasn't where a normal crossing would be expected. It was in the middle of a block, in other words. And so it wasn't at a crossing area where people would normally cross. But in this particular instance, Disney was crossing people at this point. The limited pedestrian safety, which is published on that code, my expert said means that you don't put it where people will be crossing the street. And that was the issue. And obviously, I couldn't take the position that it was not not built correctly, or it was a defective storm drain. And that's not the law. The law is not that you don't have a negligence case unless you can prove that something is built wrong. Otherwise, products liability would be the issue in every case of negligence. So anyway, we had Mr. Tipton's testimony, and there was no testimony to contradict that. And
was it your position that they were negligent in placing this storm drain where pedestrians would cross, or that they allowed pedestrians to cross where there was a storm drain, or does it matter?
Well, in their method of operation, they were allowing and they were directing people to cross the street where the storm drain was located. And my client and the two other people that were approaching that did not see it until she stepped in it. And they said when they got there and they saw her on the ground and they were trying to figure out, then that's when they saw the storm drain. So when you're approaching from that direction, the next day my client's mother went to the scene, not with my client, but just with one of the other people that was in the crowd, and she took pictures, not realizing what she was taking pictures of. And those are the pictures that went into evidence. So the pictures are not designed to prove the point. They were just designed to show the scene, generally speaking. And what the pictures show is when you're standing out in the street and you're looking at this scene as my client was approaching, you see a storm drain very clearly there. When you're approaching it from the opposite direction, you don't. And so it's my position that the judge deviated from his role as a judge in this case by granting a directed verdict when, in fact, there were material issues of fact for the jury to decide. I'd like to reserve the remainder of my time.
May it please the Court? Your Honors, my name is David Knapp. I'm with the firm of Cabinet Smith, Tool & Wiggins in Orlando, Florida. I'm here today on behalf of the Appleese Walt Disney World Company and Walt Disney World Hospitality and Recreation Corporation. This case involves a sidewalk the plaintiff stipulated met code and was not defective. It involves a curb the plaintiff stipulated.
Well, if there was a big hole that was open and obvious, and your attendant knew about it and was directing people to cross the street right where the hole was, they'd have some negligence there, wouldn't they?
That's a defect, Your Honor. That's a defect. Not
That's
only
what
did they
this case
stipulate
is all
that
about, active negligence, as opposed to essentially a premises liability where you're essentially saying that there's a dangerous condition on the premises. Isn't this basically a case of active negligence? Method of operation, that's what method of operation is when you're talking about the way that a business conducts its operations so that it's dangerous to its customers.
I think two things on that, Your Honor. I think one, it is a premises liability claim because they allege that this was a dangerous and defective condition that was not open and obvious. I think two, that with regard...
Isn't it a method of operations case?
I don't necessarily...
That has to do with active negligence on the part of the premises owner in the way that the premises owner either keeps its premises or conducts its business and how that affects its customers.
I think it can be intertwined, Your Honor, but I think primarily it was a premises liability claim, and then the claim is that they brought somebody to a location that was not defective or unreasonably dangerous. I think that's where that comes into play.
It may not be unreasonably dangerous in and of itself, and that may be true, but when you have a method of operation combined with this condition on the premises, that may make the difference. Isn't that right?
It could. I don't think so. I do not think it does in this case.
The standard is what a reasonably prudent person would or would not do under the circumstances. And you have a crossing guard that's directing people that are directed into this area where the storm drain is to cross the streets in that area, and directing people to cross when the crossing guard determines that it's appropriate for them to cross. And this girl stepped off the curb, didn't see it, and...
I think a couple different things with regard to that, Your Honor. First of all, this plaintiff testified that she was not into this area due to anything related to the handicapped area or these hedges. Those are complete red herrings. She testified she never even saw these handicapped stripes, didn't notice the break in the shrubs. She doesn't know how she got there.
But she was with the group, right? So she may not by herself have seen these, but she was with the group that was arguably herded that way. Did anybody else say they never saw?
None of them testified that they were funneled to that area by any of those items that were raised. If you look at the overhead shot of this area...
Was the area designed so that the invitees would cross in that area?
No, it was not, Your Honor.
Was there evidence presented to that effect?
No, there was not, Your Honor.
Was there any reasonable inference that the jury could draw based on the evidence that was presented that that's what Disney World did?
No, I do not believe so, Your Honor. I do not believe so for this reason. Nobody testified that they were drawn to it by that reason. These handicapped spaces are required by law to be there.
Why did they have a crossing guard in that area directing people to cross at that particular spot then?
Your Honor, our position is that they did not, and there was definite evidence on that fact.
Was there evidence to indicate that there was a crossing guard employed by Disney World to direct people to cross at that location?
There was evidence given by, there was testimony given by two of the other teenagers who were crossing with her at this time. This was a group of teenagers who were going over at that time. But the testimony of the plaintiff herself... Was there testimony in the record that the crossing guard was in that location and that the people that were in that location were directed by the crossing guard to cross in that particular location? There was testimony by, I believe, two of the other... What
reasonable inference should the trial judge have drawn from that in determining whether a directed verdict should have been entered in this case or not? Wasn't it a reasonable inference to say that Disney World had a crossing guard directing people to cross at that location, and a reasonable person would not have done that based on the fact that the storm drain was there at that particular spot?
I think the answer is no, and I'll tell you why. I'll tell you why if you give me 1 second to tell you.
All right, you have it. Go ahead.
Plaintiff testified, the plaintiff herself testified, again, that she was not brought there by the handicap striping or this break, but that she came back that way because of the crossing guard, alleged crossing guard. However, she also testified that this was the person who had waved the vehicle into and directed the vehicle into the parking lot in the first place. And that's the guard that they were going back to. If you look at defendant's exhibit number 4, that's in the record and part of the record here, you can see the location of this incident. You can look down the curb. You can see where the crosswalk actually was marked. And you can see where the cars come in, where the driveway is. There is absolutely no driveway anywhere from that location where the crosswalk is and where the driveway comes in. There is nothing going back this whole curb. There is nowhere for a guard to have waved any car in except, if you look at that picture, from the crosswalk. If you look at Plaintiff's Exhibit 2 in the record, which is a picture looking at from the sidewalk that she had to walk across over the street, you will note in that picture that there is, and I have another copy, it's in the record. I don't know that if it's a part of the appendix, but I can bring it up if you would like to see it, Your Honors.
Where was the crossing guard standing in relation to the storm drain?
It depends on whose testimony.
At the time of this particular incident, where was the crossing guard?
It depends on who you listen to. One of them.
Well, wait a minute now. You correct me if I'm wrong. We have a directed verdict that was entered in this case, right?
Yes, Your Honor.
What is the standard for the trial court to utilize to determine whether a directed verdict should be rendered? What is the standard?
The standard is slightly different from a summary judgment, but similar. Summary judgment, he has to take the burden of proof.
Just tell me what the standard is for. I know what it is. I want to know if you know. What is the standard?
Yes, Your Honor. The standard is that he has to take, the plaintiff has the burden of proof to prove the prima facie case. The court has to take every inference from the evidence in favor of the plaintiff.
All right. And so my question to you was, you keep going back to particular testimony. You have to look at the testimony. The trial judge has to view the testimony as a whole and determine whether there's a reasonable inference from the testimony as a whole. You just don't take the testimony of one person and say, well, based on that, there's no reasonable inference. You have to take it as a whole. You agree with me on that?
I do, Your Honor.
Okay.
I do, Your
Now,
Honor.
my question to you is, where was the crossing guard standing in relation to the storm drain when these people, the plaintiff was directed to cross?
Okay. If I could finish where I was going on that other, I wasn't quite finished. The last picture that I wanted to draw the court's attention to was Plaintiff's Exhibit 2 from the trial, which shows looking across the drain. You can see at the time it's barricaded off on the other side of the street by both orange and white barricades, and also there is a green fence going all the way across. There is nowhere to direct people to. You cannot cross at that location. Again, the photographs, because of the fence and the barricade, there's nowhere to cross to. Again, going from the first picture and the plaintiff's own testimony that she was directed by the guard who waved therein.
Was the drain cordoned off by the barrier?
The barrier is across the street, Your Honor.
And was the crossing guard standing where this X is in the middle of the road?
I believe one person testified to that, not the plaintiff, but one person did.
One person testified that the crossing guard was standing right where
directing them into the barricade.
Right. Well, directing them, the storm drain is right here, isn't it?
Correct, but they were going across, what she's saying is they were directing them across into downtown Disney.
I understand.
And it's physically impossible to get there that way.
I understand, but you had a crossing guard, people coming this way. Here's the storm drain. The crossing guard is standing right there where the storm drain is, right in the middle of the road, directing people to step off that storm drain and cross the street right there.
You're correct. According to one person, it was. That is correct, Your Honor.
Okay, and a reasonable inference from that could not be drawn that Disney World knew or should have known that would have caused danger to invitees based on what the crossing guard did in directing them to step off that curb and cross the street.
I think if you look at the other photograph, Your Honor, the one that was attached as appellant's number 6, which shows that from even behind the shrubbery, you could see that drain. You could see it, that there's never been any other incident at that location that their expert admitted you could have seen it, that the plaintiff's mother admitted you could see it, that all of these witnesses who were there admitted she could have seen it, and plaintiff even admitted she could see it, and that her view was not blocked. All indicate that.
Are you saying that the fact that there's never been any accidents there before is an indication there's no negligence in this particular case? Is that even admissible?
I think it goes to the fact one of the main issues that you, Your Honor, have pointed to in many of your decisions.
Is it admissible evidence in a negligence case to show that there had never been any prior accidents at that particular location, and for the defendant to present that evidence to show that there was no active negligence at the particular time this incident occurred? That's not admissible evidence, is it?
It's something that's in the record before this court, Your Honor, and something this court can consider.
Was it objected to?
I do not recall, Your Honor. I know that it's in the record, and I cited to it. I do not recall.
Well, you know as well as I do that in a case like this, it is inappropriate and it's inadmissible to present evidence that, well, in a case like this, where there's active negligence that's alleged, that there's never been any accidents in that particular area before, and that is proof and is relevant that this particular incident, there wasn't active negligence at this particular time. You know as well as I do that's inadmissible evidence, don't you?
I'm simply citing something that's in the record for the court to consider, Your Honor.
Is it inadmissible evidence? I mean, the cases are replete that say that it's inadmissible, isn't it?
I understand what you're saying, Your Honor. I'm simply indicating that in many of the cases which you have sat on, and you've sat on a number of these cases, and obviously are very well versed in this whole point of the law. One of the major items that you have cited in a lot of those cases has been how many times previous incidents occurs at that location. That's why I made that point in bringing it to your attention. But all of them admitted, all of the witnesses admitted that they could have seen this if they had looked, and plaintiff said her view was not blocked.
I have one more question for you.
Certainly,
the trial judge apparently at one time said, if it wasn't for that crossing guard, you'd be out of here, or something to that effect. Or a direct a verdict in a heartbeat, something like that. And then the trial judge apparently changed his mind later and said, well, I'm going to direct a verdict anyway.
Yes, sir.
What happened in between that caused the trial judge to change his mind, do you know?
I think the primary thing that happened, Your Honor, was that because plaintiff had stipulated that this was a non-defective condition, because it was open and obvious, and she admitted that she could have seen it if she had been looking, it wasn't wet, it wasn't slippery, it wasn't dark out.
Negligence.
I think that because of those things, his conclusion was, you're directing somebody over a non-defective by stipulation and an open and obvious location. That's not negligent. I believe that's the conclusion he reached, Your Honor.
Isn't that an issue of comparative negligence that the jury's supposed to decide?
I think if you're
whether the person saw it or should have seen it, or whether it was open and obvious. I mean, if there's active negligence out there, and you're claiming that, well, they should have seen it, or that they stepped over it despite the fact that they knew it, that's a pure issue of comparative negligence, isn't it?
I don't think so, Your Honor, because of this. I think what he said is on premises liability, you're owed two duties. You're owed the duty to warn if it's not open and obvious. Here it was open and obvious. You have to maintain it in a reasonably safe condition. This was maintained in a reasonably safe condition. So if you are directing them over that type of area that's not defective, then you're not negligent.
What is the duty in a method of operation case when you're alleging negligence based on a method of operation as opposed to a defective condition of the premises?
But I think
different than that, isn't it?
You have to act reasonably, but I still think what the judge said is here it was not unreasonable, because what the allegation is you're directing, what plaintiff said is it's unreasonable because you're directing them over a defective or unreasonably dangerous condition.
Are you talking about reasonable in terms of duty of care or causation?
Talking about reasonable in causation. Duty of care. I was talking duty of care.
Duty of care?
Because what the judge, as I said, I believe said was to direct them across an area that is not defective, not unreasonably dangerous, cannot be negligent. I believe that's what the court said. That they had a duty to act reasonably, but they did not breach that duty because this was not an unreasonably dangerous condition as a matter of law.
Isn't it a jury question whether the defendant should have anticipated that the guest's attention could be drawn away from something that would otherwise be an obvious and open condition? Isn't that really up to the jury to decide that?
In this particular case, Your Honor, I think the fact that, that everybody admitted they could have seen it, that there was nothing blocking their view, that if she's behind people, she's actually going to see other people stepping over. I think all of those things show that reasonable men could not differ. I can see that I've convinced Judge Sawaya.
No, I think what you're talking about is reasonableness as it relates to causation, and that's generally, in 99% of the cases, a jury issue. The duty of care in terms of whether this was reasonably foreseeable or not, to me, is not really an issue in this particular case. I mean, if you have a crossing guard and they're alleging active negligence on behalf of the premises owner based on method of operation, it would seem to me that if you have a crossing guard directing people to cross in this particular area, that any reasonable person would know that creates a zone of danger. It seems to me what you're talking about is reasonableness as it applies to causation. In this particular case, was it reasonably foreseeable as it applies to causation? What caused the injuries here?
I understand exactly what you
disagree with me on that.
I understand exactly what you're saying, Your Honor. I would leave with two last points.
Okay.
One, I do want to make it clear that we do not agree for a moment that there was a guard. There's the testimony of the person who was there cleaning up the protein spill, which means someone got sick. Never saw a guard. He was the first one there, in addition to the pictures and the things I showed. But additionally, our position is that this was not an unreasonably dangerous condition. It was open and obvious, and therefore directing someone across that is not negligent as a matter of law. And therefore, we'd ask you to affirm it, and we thank you very much, Your Honor.
Okay, thank you very much. You did a good job, by the way. Very good job.
In all fairness, counsel was not a trial lawyer, attorney at the trial, and the witnesses were not testifying that they could easily, that they were approaching, as he said. The two witnesses said that they did not see they saw the crossing guard. They went this way because of all the markings and so forth.
He knew the record pretty well. Counsel did.
Well, he knew the record pretty well, and I'm not criticizing for it, but he made some comments about what went on in trial, which is not correct.
Sometimes those lawyers who didn't handle the trial know the record better than the lawyers.
Well, that could be, but I was there, and I remember, and this is very, it's indelible in my mind. He indicated that this young girl, 15-year-old girl, she was sitting in the back of the car that went into the parking lot, and she indicated in her testimony that she did not. She saw a crossing guard as they passed them, but she was not involved in the parking of the car, or how the car got in the parking lot, or anything like that. She's a young girl, 15 years old. This was a very serious accident, and when it happened to her, the last thing in the world she was thinking about is how she got there and how she walked and where she walked and all that. And so she candidly acknowledged it, and it's to her credit. She didn't make up a story or anything. She said, I don't remember. But she didn't say that she didn't do it, or she didn't say that. And the other two witnesses actually testified that that's the reason they walked there, is because that was the way they thought they were supposed to walk, and they saw the crossing.
The opposing counsel said that there was very scant evidence that there was even a crossing guard there. Where did that evidence come from?
The evidence came from, number one is when my client testified that whenever she fell, the crossing guard came to her and tried to get her out of the road because she was blocking traffic. And so then as she was gotten out of the road, then this other person came up who was apparently a Disney policeman in the parking lot somewhere, and he gave her a card indicating it was a Disney card, and he gave her a card as to who her parents could get in touch with. She was 15 years old. The ambulance could not take her because she didn't have a parent with her to the hospital. And so later, some of the other children she was with took her to the hospital, and the hospital would not treat her.
One witness gave direct testimony that there was a crossing guard standing there, right?
Two of them.
Yeah, that's what I'm asking you. I mean, what witnesses were these that said that there was a crossing guard standing there?
The two witnesses, in addition to my client, was a Christy Mathau, Matthew, and she testified that she saw the crossing guard, and that's the reason she walked in that direction. And the
That's
other
how
was,
they placed the X in the picture there? That's how they...
yes, sir.
Okay.
Yes, sir. One of those witnesses placed that X there.
All right, okay.
And the other one was Kelly VANA, and Kelly VANA is her 17-year-old stepsister. And Kelly VANA was behind her a couple of steps, and she said, yes, she saw the crossing guard, and she did not see the hazard. Neither one of these girls said they saw the hazard until she fell into it. That's all I have here.
Okay, thank you. Thank you both. Well argued on both sides. Did a good job, and both of you did a good job, and we'll render our decision, and we can get it ready.
And no coffee today, right?
No coffee today.
Thank you.
All right, thanks.